Defendant is entitled to full notice and disclosure of the nature and cause of the charges under the Sixth Amendment and the exact commercial or statutory basis for the plaintiff's authority, whether this case involves contractual obligation, and if so, the terms, any fiduciary or financial capacity in which the plaintiff or court is acting, and the courts have been held that where the prosecution or complaint proceeds under vague or generalized charges, a bill of particular is proper and necessary to ensure due process and fairness. All right. So, U.S. versus Bornovsky. The purpose of a bill of particular is to enable a defendant to prepare for trial and avoid surprises. Additionally, under, we'll say, the Alabama Rules of Criminal Procedure or equivalent, a court may order the prosecution to provide further details to clarify the nature of the charges. Pretty much request. It's all the stuff y'all been writing affidavits, but you haven't been using it correctly. You just have to know how to do it according to the rules. Motions is your most powerful thing. Motions is what's going to actually move the court. Motions will grant you a hearing every time. And if a hearing is not granted based upon your motion, then guess what? It's a violation of due process. Understand that. So now we do a motion to compel discovery responses. If they don't answer your interrogatories, your request for production, then now we're letting them know we're making the court make them compel. Okay? I'm not going to go through all of that, but this is what's necessary to do if they don't do that. All right? Now, if they don't, after you've done the compel, if they give you vague answers, don't really answer it in some type of way, you know how they do. And if they don't give you the production of what you're asking for, now you do an admission. So now, guess what? Pursuant to Rule 36, each request must be answered or objected in writing within 30 days. Failure to respond constitutes automatic admission. So that means they admit. Which now brings us to subpoena. So we can literally subpoena the court so we can actually be able to see certain documents that are being recorded, and we want them to produce these documents. So all the documents that we asked before is pretty much in here the same way, and we can just tell them where to meet us at, and so that we can have these documents for our evidence, our own evidence. Okay? So Section 8 is putting the court on the record.